May I please, Your Lordship?
Yes.
Your Lordship, item number 20 and 21. The conducting counsel is out of.
Mr. Devnath?
Yes, Your Honor. Is indisposed for today.
Why he is avoiding this case?
Lordship, on 24th, they filed one affidavit, Lordship, and
Without permission of the court.
whether the permission of the court was taken or not, that we need to ascertain from
Was
the court.
permission taken from the court to file the affidavit?
Your Honor, I don't know.
You don't know. Where's Mr. Devnath?
He's out of station.
Gone to Tripura? No. Just nearby, that means 1 week, yes.
Wait for the state here.
We'll see that next week. Whether the affidavit is filed with or without permission, without leave from the court, yes.
Obliged, Lordship.
My lord,
Your Honor, item number 21 also.
Yes, 21. 20 and 21. Yes.
Much obliged, Your Honor.
Lord, I beg to make a mention of item 29 and 30 of the hearing list. Lord, this matter can kindly be fixed either on 9th or 16th.
No, this matter is reached, it was heard last time, correct?
My lord, so my lord, because I was informed that Todi sir will be taking up the matter.
Last time the junior told you.
His son was here, my lord. So this morning, in fact, they called me up and informed me.
You are appearing for?
Lordship responded one for the Lordship.
Well, Muzika is not here also. 2 weeks, yes.
My lord, if it is, because as he is requested, if it can kindly be listed either on 9th or 16th, my lord.
16th of May?
Any of the Tuesdays, my lord.
You take a date. Give 16th of May.
My lord, obliged.
Obliged, Lordship.
Yes.
May I please, Your Lordship?
Yes.
I beg to mention item number 34 on behalf of Mr. Abraham.
What's wrong, Abraham? He's not well.
He's out of station, Your Lordship.
In fact,
That's
this
why
matter is conducted by Soman.
he is also not available.
Who's so many?
Mr. Sengupta.
Person.
But he is also not available.
This is that old pension scheme versus
Next
new
week,
pension
any
scheme.
day, Your Lordship, because I am not
You're
here.
not obliging the court by saying next week any day.
No, Your
It's just that
Lordship.
the matters in the list today. Because what's the point of having an advance list?
Your Lordship
That
is
is the
on
thing.
leave, Your Lordship. Kindly adjourn the case.
Can it come next week, Your Lordship? Lordship, there's some urgency in this matter.
1 week, okay.
Yes, Your Lordship. Much obliged, Your Lordship.
May
Yes.
it please, Your Lordship, I beg to mention item number 17, my lord.
17.
I'm appearing on behalf of the conducting counsel A. Sattar, my lord, who is currently ill, my lord.
On behalf of Isatar,
I have a very strong objection to this, Your Lordship, because matter was almost heard, and after
matter was heard, almost
heard,
complete.
not complete,
Almost
and
complete.
at that moment they changed the lawyer. Then the new lawyer came. He filed an application that some additional document to be taken. Then after that he did not appear, Your Lordship. Last time also he did not appear, and a matter is pending for very long period. And number of lawyers he keep on changing.
I think maybe the lawyer is not getting material instructions.
That is the maybe the
That must be
problem.
the problem.
Otherwise, there is no such reason that 6-7 lawyers he has changed.
There's no reason, right? These cases like this sometimes
No,
when
Your
lawyers don't
Lordship,
get,
if
don't
this
get
is to be
material
allowed,
instructions.
this should be allowed with a heavy cost, Your Lordship. Because my client is every day he has to spend the money.
If I may allow to present before the court the prescription prescribed by the doctor, my lord.
Prescription? No. We'll take your submissions at the bar. MS K Guru, right? On behalf of Mr. Isatar, praise that the
They
matter
can
be
appear on
adjourned
VC if they so
as
desire.
he is unwell. When we will not, we will make a remark. When do you want it?
4 weeks, after 4 weeks, my lord.
No, 4 weeks is too long a period,
This might
Your
be taken
Lordship.
as a last chance, my lord, 4 weeks.
Let it be fixed on 11th May.
No, I don't know. Yes, list the matter on 11th.
As a last chance, Your Lordship, because number of adjournment he has taken, Your Lordship.
Then they'll change the lawyer. Yes. Yes.
Much obliged, my lord.
11th of May. Yes. Okay.
And my objection may be recorded.
Yes, Ms. K Guru. on behalf of Mr. A. Sattar, learned counsel for the appellant, prays that the matter be adjourned as the arguing counsel is indisposed. Stop. Next line, Mr. B.K. Jindal, senior counsel on behalf of the respondents, has voiced strong objections in view of the fact the matter has been left hanging when on the earlier occasion hearing was about to be concluded. However, in interest of justice, let the matter be fixed on the 11th. Endeavour shall be made to dispose of the matter the next day. Yes.
May I please, Your Lordship, I beg to mention item number 23, Your Lordship.
Number?
23.
23.
Let this matter be taken up after 2 weeks, Your Lordship, as Mr. SD is on sanctioned leave, Your Lordship.
Who?
Mr. S.
Where's Mr. SDEP?
Because there's a briefman, Your Lordship. Because there is a briefman from my seniors.
BP?
Briefman, Your Lordship.
Okay. After?
2 weeks, Your Lordship.
No objection?
No objection, Your Lordship.
2 weeks, yes. On account of bereavement of Mr. SD, yes. Yes.
Similar prayer for item number 27, Your Lordship.
27 years.
Much prayer, Your Lordship.
Obliged, Lordship. May it please, Your Lordship. Your Lordship, I beg to mention item number 31 and 32, Your Lordship. I pray that the matter may come up after 2 weeks, Your Lordship.
Why?
The conducting counsel.
What's the matter about?
This is land acquisition matter, Your Lordship.
No difficulties. After 2 weeks.
Okay, 31, 32.
Yes, Your Lordship.
2 weeks, yes.
Highly obliged.
May I please, Your
Hallelujah.
Lordship?
Yes.
I beg to mention item number 25.
Hallelujah. Yes, 25.
Yes, Lordship.
Mr. Philemon's bereavement
Yes, Lordship.
after 1 week.
Much obliged, Your Lordship.
Obliged, Lordship.
1 week.
Obliged. My Lord, I beg to mention item number 19, my Lord. When we fix it, my Lord, after 2 weeks, my Lord.
Last time who took time?
The respondent has taken time.
They took time?
Yes, my Lord.
Sure.
My Lord, the order reflects that, my Lord.
I'll make a rap sheet done of the journal in this matter, respect 2018 matter. 1 week, yes. We'll do it after 1 week. Yes, Mr. Basmatari.
I beg to mention item number 18, Your Lordship.
18. This matter is about to be concluded. Who's for the other side?
Your Lordship, I have no objection. However, I would like to pray for me to be allowed to supply this copy of a list of events today, so that it will
List
be on board.
of?
Events. It will be on board for the next date.
Mentions made on behalf of Mr. Qureshi. Where is Mr. Qureshi?
He's on sanction leave.
Oh, still been sanctioned leave. Mr. Lingdo? No, you are?
PV Promotion on behalf of
Commotion on behalf of the respondent has submitted a list of events. Yes. You give it to the court master. This list is matter after? Yes, Mr. Basmatari.
2 weeks, Your Lordship.
These matters all become half cooked. Yes. Right. Yes.
Obliged, Lordship.
Call out the list.
Similar prayer for item number 26, Your Lordship.
Kamal Hassan or Kamal Hussain?
Petitioner, my Lord.
Yes. 2 weeks, yes.
May it please, Your Lordship, I beg to mention item number 33 as well, my Lord.
He's giving this court a holiday. 33, Mr. Mozika. 2 weeks, yes.
Much
I'm
obliged.
for the petition. I'm for the petitioners.
Very good. Yes.
May it please, Your Lordship, I beg to mention item 24, Your Lordship.
This is like tag team mentioning. 24, yes.
And similar prayer for item 28 as well, Your Lordship. 28.
1 week. It is 1 week. This matters 21 matters, yes.
Much obliged.
Not mentioning 22. No. Yes. Oh, 22 is not. Yes. Okay.
supplementary list. Item number 1.
Why are you not here when you file a motion? And why did you come over or anyone mention it on your behalf? It's discourtesy, you know that. You're lucky that we're not dismissing it. You know, matters come for motion, there's not even one counsel who even mentioned on your behalf.
Lordship, actually, Lordship, I was out of station and I.
Out of station is your duty to put someone in your place.
Yes,
ready to
Lordship,
move
yes,
then.
I requested my colleague, but she also could not come on
This
time.
is a colleague and she refused you.
No, Your Lordship.
Then?
She could not appear on time, Lordship, and the matter was.
It's
called.
not done.
My apology, Lordship. My apology.
It's absolutely discourtesy.
Lordship, my apology, Lordship.
You have to pay costs. You keep repeating it. Yes.
No, Your Lordship.
Yes.
Your Lordship, let the notice be issued, Your Lordship.
That was to be issued. What's the matter about?
Lordship, the matter is all about that, Lordship. I'm impugning the order of the respondent number 2, that is annexure 3, page 23, wherein the respondent number 2 directed to issue annexure 3, page 23, wherein the respondent number
Annexure 3, page 23.
Yes, sir. Wherein the respondent number 2 has directed to issue joint patta in favor of me and in favor of respondent number 5. And the facts of the case, Lordship, is that...
Who is respondent number 5?
Is my brother.
Why don't you share property with your brother?
Lordship, there is a will. My father has executed a will in my favor and bequeathing all the properties, the landed properties in my favor, Lordship.
So you obtain a probate, you obtain a probate on the will.
Lordship, for that, Lordship, I do not have any instruction. But the thing is that, Lordship, the respondent number 5, being well aware of the fact that there is a will in my favor, he filed an application before the respondent number 3. Then, on the basis of that application, the respondent number 2 passed an order dated 5/9/2018.
5/9/2018 passed an order, now you've come against that order now.
No, Lordship, that is annexure 2. That
right.
is annexure
So you're impugning this also?
Yes, Lordship. I'm impugning this.
So what did you do after 5/9/2018 till when this other order was passed last year?
Lordship,
what were you doing? Okay, read that order, annexure 2. What does it say?
Annexure 2 is saying that, Lordship.
5/9/2018.
I'm just reading the relevant portion, Lordship.
No, read the whole thing.
All right. I have heard the learned lawyers for both the parties. I have also perused the records. The facts of this case are like this. One Kalikanto Madok and had left landed properties, 16 plots of land at or around Mahendraganj of this district. The said Kali Mahanto Madok left 2 sons, the appellant and the respondent. In normal course, all the ancestral properties of late Kalikanto Madok should be inherited by both the appellant and the respondent jointly. But the respondent claims that a will was executed by his father in his favor and thereby the appellant was deprived from share. However, despite many chances given to the respondent, he could not produce such a will.
So you could not produce a will?
No, Your Lordship. I have produced,
but read it?
But it was not recorded, Lordship. I have produced the will.
Yes.
When, Lordship, I have the will, why I will not produce, Lordship? But it was never recorded, Lordship.
Never probated, yes.
In the absence of any documentary evidence, the properties of the late Kalikanto Madok should be inherited by both the appellant and the respondent jointly. A property cannot be allowed to remain in that man's name. Hence, I direct the Assistant Settlement Officer to grant mutation of all patta land in question in the appeal in the joint names of the appellant Sunil Madok and respondent Kamini Madok.
See, Mr. Deb, the case was disposed of 2018, whereby he said that you cannot show anything to otherwise, that why you and your brother shouldn't share the property. After this, what did you do? After 5/9/2018? This is by the executive member. What happened after that? What did you do?
I have not received this order. I have received...
No. When did you receive this order?
Lordship, this order, Lordship... Lordship, I have to get instructions.
See, Mr. Deb, I'm very sorry, but you should prepare your case better.
Lordship,
see, I've heard lawyers of both sides.
Yes.
In the absence of any documentary evidence, the property of so and so, that means your father, she made up a both. You could not produce anything. So I passed orders, of course, case stands disposed of. And the Assistant Settlement Officer directed to mutate the properties in both your names, correct? 2018.
Lordship.
If you agree, you're not aggrieved then. You didn't do anything after that. You went to sleep.
Lordship, I may be...
And one fine day, when a mutation order is passed, that is 28 November 2022, then you woke up suddenly.
Lordship, I may be allowed to file additional affidavit to bringing on record the
What did you do within 18 and 22?
Lordship, I can explain, Lordship. I may be allowed to file one additional.
You explain now.
Lordship, as of now, Lordship, I do not have instruction like why there's a delay, Lordship. So kindly.
So when you interview your client, you don't ask him what were you doing from 2018 to 22. As a young lawyer, the first question should come to your mind.
Lordship.
You asked him. What did he tell you?
No.
He said, I don't want to answer, just do the case. Is that what he told you?
No, Lordship.
Then?
Lordship, I may be allowed to file one additional affidavit.
No, it's not a question of additional affidavit. You have to satisfy the court at least, even to issue a notice.
True, Lordship.
Even to issue notice, you have to show materials on record that, that warrant that, yes, your right somewhere been infringed, and then like a notice is called for to ask the respondents to answer to your petition. But in the absence of anything,
Lordship, probably there must be some correspondence. Actually, Lordship, I may be allowed to file additional affidavit, Lordship.
You will not allow right now. You try to get some instructions first. Mr. Bita prays him out to obtain some instructions on the queries put by the court list after 2 weeks for motion. You have to be very complete in what you do.
Main list, item number 1.
My lord, this matter, me and my the colleague private respondent seek some accommodation from my lord. Matter make up after a week. My friend also, Mr. Bikram, was out of station. He informed me.
Who? Bikram, your lordship. Yes, out of station. So can 2 weeks time, your lordship.
Why you want to take sick time? For what reason? You're not ready.
My lord, I'm unable to prepare. My lord, I'm ready to do it by next week, but my friend informed me that he's out of station.
2 weeks, your lordship. I could be happy to find your lordship.
Mr. Kanta, nothing to say.
Nothing to say.
Parties make joint requests due to personal difficulty that matter be adjourned to 2 weeks. Stop. In consideration thereof, as prayers allowed, is the matter for 2 weeks also and so.
2, 3.
Where's Mr. Jha? He was here just now. By order dated 12/4/2023, counsel for the petitioner was to obtain status of service on the respondents number 8 and 10. Stop, and to file affidavit indicating service. Stop. Next paragraph. Today, office note. Today, however, the office note indicates that the said affidavit of service has not been filed. Just after 1 week.
4.
To enable the petitioner to obtain status. Yes.
May I please, Your Lordship? Your Lordship, I humbly pray 2 weeks time, Your Lordship, to file additional affidavit.
Lordship, they keep on taking time on the instruction because they have in that RTA information, they have informed that salary has been cleared till March 2022. But yes, as per their instruction, yes, 22. Till now they have not filing that order has been passed long.
I humbly pray, Your Lordship, 2 weeks time, Your Lordship, to file additional
Is it
affidavit.
regarding salary, Lordship?
Yes, Your Lordship.
I have not been paid since October 2022 till today. I have not received my salary.
So far as this is concerned, we have already released our grant also now, 2022-23 also, to all the municipal board, including Batmara. So, my lord, so far, why they have not released?
You are paying for municipal board.
My lord, yes.
Mr. SD.
No, you are for municipal board, not for Mr. SD. You and Mr. SD are just counsels in the case. Okay. since he's not here, since as Mr. S is sanctioned this matter, next week.
Statement of my learned friend may be stated because this, Conley he stated that money has been released.
Note of the statement she made and submit again next day.
Let her find up with
1 week. Yes. What is the defects in the condemnation application?
Mr. Gautam has appeared for respondent.
I'm appearing for respondent 2. That means I have not been
giving
served with the
respondent
copy.
number?
Respondent number 2.
There's a delay of 844 days.
I have given him the copies right now.
844 days, but
831
the order
days.
was passed on 27/8/2018. So it has to be it has to be more than 800 and.
You file your objections?
Yes.
Has he corrected the defects?
Yes.
What issue, what defect issue last time?
They have not appeared that time. The para number 3, this case number, miscellaneous case number 311T 2018.
Yes.
This is wrong. This is 2013.
Oh yes, 8 has been mistaken maybe
And
by
also
the
it's
typist
not
maybe.
miscase. This is the CIS number. The miscase number is
Just above the previous para 2 at the end, the same number is there, 2013. Here typist mistake, I think.
And also no,
Why are you typing SCIS number 311T?
Yes. Para second last line also the same case number is there.
Correct,
It is
then correct the
13.
defect.
While proofreading maybe it slipped.
Yes,
the eyes.
Mr. Bora praised for to correct the typographical defects that have occurred in the condemnation application. Stop next paragraph. Mr. K.C. Gautam, Senate Council, has entered appearance on behalf of the respondent number 2 today. What about number 3?
Mr. H. Nath, I think.
Yes. You appeared last time?
Yes.
Yes, 1, 2. So no further notice called for. When are you going to correct? Defects will be corrected within 1 week.
Yes.
List thereafter for objections.
Item number 6.
May I please, Your Lordship?
Yes.
That the contempt petition is not survive. In view of the order passed on 27/4/2020, my Lord.
By this court?
Yes. In para 8, my Lord, in the
27/4.
Yes, 27th April 2022, my Lord. Page number 13, para 8, my Lord.
Of your affidavit?
A BSc, my Lord.
Of your affidavit?
Yes. I have already submitted it.
No, where you see?
No, that is the not affidavit, my Lord. The writ petition itself is there. Though I have mentioned.
Page?
Page number 13, 1-3. Para 8, my Lord.
Now what contempt alleging, Mr. Sheikh?
Now only the one VSC, my Lord. Not the Haripur VSC part 1.
My
That is
Lord,
the case of the...
I am not on that, Lordship. My Lordship order is very clear. Lordship, what my learned senior is referring the order, Lordship, that is at page
13.
Page 13 of my
petition, yes.
Petition, Lordship. Page 14, Lordship.
Okay.
It is expected that the state respondent shall complete the entire exercise within 6 weeks from the date of receipt of this order. The court says that if bifurcation is permissible as per law, you take a decision and accordingly you conduct election. And if bifurcation is not permissible, then also you take a decision and conduct election as a single entity. I am not here that it should be bifurcated and election should be conducted. I want that they should comply the order, either as a one entity or as a bifurcate, two entity. That is my case. Because in the earlier round of litigation, they have undertaken, they will conduct the election. Based on the undertaking given by the BDO, the court has disposed the writ petition, Lordship. Then subsequently, some writ petitions were filed, then common orders were passed. And in the common orders, my lords have given some directions.
Yes.
So
now what do you agree with now?
Now they should conduct the election.
Elections have been conducted as yet?
No, not yet, Lordship.
Why?
That is no thing is because we have pursued this matter as per this order. We have to get the clarification from the higher authority, my lord. And the meanwhile, that case, this is 252 of 21 has been pending, and they have also given the undertaking that we will withdraw the contempt petition. I have enclosed that legal notice, my lord, in my affidavit. Now we will conduct it, my lord. Within 1 month we will finish it. But not this Horipur part 1, my lord.
Whatever may be.
No, that is your case. Your case is for part 1, Horipur part 1 only.
I have not mentioned 1 or 2. I just wanted to comply the order.
No. Comply the order. Your order cannot be complied because of the subsequent order.
To let
that one will comply it.
I have filed contempt with regard to the subsequent order also, Lordship.
Who has the contempt?
Lordship.
Who has the other contempt?
I have brought to the notice of the Honorable Court, Lordship. I want that.
1 second.
And page 8, they have given that.
1 second, sir.
In the affidavit, page number 25, my lord. For there is various reason for the delay. Yes. Yes.
What do you say about this page 25 where they've annexed this? This is from you only.
Yes, Lordship.
This legal notice.
Yes,
then,
Lordship. Because he has given the undertaking like.
No. Then why have you given this notice, Mr. Sheikh?
He has given the undertaking. If we withdraw, I will conduct the election just before the vacation of the court, Lordship. Then based on the undertaking, then my client says that it's okay. Then client, I will not follow.
Contempt is not for you to withdraw.
Yes, true, Lordship.
Then you how do you give the notice? This under your signature.
Yes, Lordship.
Then
on his instruction, Lordship. Kindly see, Lordship. Here he has.
See, you wrote, since the contempt is not interested to pursue the case and the same could be withdrawn instruction as
on
soon
his
as
instruction.
the matter is listed after vacation.
Yes.
We'll close it. This contempt. Nothing survives for consideration in instant contempt application. The same is closed. We're not making any remarks.
My lord, down he has given the undertaking, Lordship.
Much of it.
7.
It's not done. It's not done.
Please, Lordship. This is supposed to appear for appearance of respondent number 4, Your Lordship.
You've taken steps.
Yes, we have taken steps. We have filed the affidavit of service also. It says he has received it in the. To that effect, order has been passed on 12.
Where's the affidavit from the government?
Affidavit government they have not filed, Your Lordship.
We've just received additional instructions day before, Your Lordship. So I'm praying.
When was the matter filed? How many times have you taken for affidavit?
Yeah, they have been taking on time, Your
September
Lordship.
2022.
You give the instructions, we'll dispose of the pension matter.
Your
This
Lordship,
is not pension matter. This is
in
this is regarding the appointment of teachers because I cleared that
Your Lordship,
they
in
take
this
that
case,
participant.
It's a deficit school, Your Lordship.
I have
So
passed.
the government, Your Lordship, all we have to do is give approval. Appointment is done by respondent number 4, Your Lordship.
The government they are not giving the approval, Your Lordship.
We've not given approval, Your Lordship, because there were some anomalies, Your Lordship, in the interview. So because of
So in
that,
part
we
order
had-
they don't appear.
And then respondent number 4, he is the main respondent. He is not
Yes,
appearing before this court. Because from my part, I have no, because I already cleared the exam.
File affidavit
I
in
passed
1 week.
also.
MS Island principals allowed 1 week's time to file affidavit. Stop. None appears for respondent number 4. If no appearance made on the next date, the matter shall proceed ex parte.
Lordship.
Obliged, Lordship.
Much less, Lordship.
List on so and so. Yes, what's the matter about?
This is Lordship.
Regarding school money.
That state has filed the counter, Lordship.
When you file a counter?
Counter, Lordship.
Filed it on
the last date, Lordship.
My lord, we filed it on 12 4, my lord.
12.4. You want to file rejoinder or no?
No, my lord. Paragraph 9, Lordship. 9, yes.
Of the affidavit?
Affidavit.
And what did he say?
The sub-para. Down, Lordship.
You filed 19.4.
Page 4.
This is by R.K. Hajong.
Yes, Lordship.
Yes, my lord.
Paragraph?
Sub-para 9, Lordship. Para
Yes.
9, top below.
Yes.
In this regard, is further mentioned that none of the names as per the so-and-so of the student studying in so-and-so submitted by the headmaster comes so-and-so dated so-and-so is reflected approval dated so-and-so. Hence, it may be clarified that the aforesaid ad hoc managing unit approval dated was obtained by misleading the then issuing authority. So, by only prayer, the term of the ad hoc is going to expire July this year, Lordship. So fresh.
Who was appearing with the other respondent?
Private respondent on the last occasion, they had prayed for time to file an affidavit.
They filed affidavit, I think.
They have filed, Lordship. Now only the thing
Yes.
is that
You appear for Mr. Hassan. What do you have to say?
Your Lordship will pray for some more time to file affidavit. It is the conducting council.
You've seen the affidavit filed by the state.
Your Lordship, the conducting council is outstation, Your Lordship.
You have the file with you.
No, but like I don't have the affidavit with me. The signature of the client is not there. By the next date, Your Lordship.
This list is matter on Monday.
Monday, Lordship, Monday.
Yeah, problem. Yes, after 1 week. Yes. The our council respondent number?
5.
5. That's present report.
9.
Sting bud.
My lord, only respondent number 4 has filed the affidavit.
Yes, Your Lordship. I am appearing on behalf of respondent number 4 and 6 and affidavit.
4 and 5 or 4 and 6?
4 and 6, Your Lordship.
Last time Mr. Kriam's of 4 and 6, okay.
Yes, and respondent 4 rely on the affidavit file for respondent number 4, Your Lordship.
What? Respondent number 4?
Respondent number 6 doesn't file the affidavit but rely on the affidavit file by respondent number 4, Your Lordship.
Who's appearing for CCT Sangma for 5? Who's Mr. CCT Sangma? They file affidavit.
They do not wish to file the affidavit, my lord. They have mentioned.
Sub 5?
Yes, my lord.
So what do you want today?
My lord, if the respondent... No, my lord. I want to file a rejoinder.
Okay, Mr. R. Hassan. Council Petitioner, please be allowed to file a rejoinder to the affidavits filed by?
Respondent number 4.
Number 4.
My lord, if they adopt the...
Yes, it is submitted. It has been submitted by Mr. Sorry. Yes, Imarwin. That the respondent number 6 will place reliance on affidavit of respondent number 4. Only after 2 weeks for rejoinder.
Obliged.
10.
Lordship, in this matter, the affidavit is ready, Lordship. I'll file it today. I've served the copy also.
Mr. H. Karmi, learned senior, additional government advocate.
Due to oversight on
the be filed in the course of the years.
Lordship, there was an interim order, but due to oversight, Lordship, the interim order was not continued till next day.
Did you put an application again? If you require it.
11.
Yes, after 2 weeks.
Please, Lordship, as per the order dated 29/2023, I have filed in the implement application because there to implement JTTC. And there is an order 29 March 2023, Lordship, whereby I was directed, the petitioner is directed to file the implement petition to implement the JTTC.
Yes, against the municipal board also.
Lordship.
What is the relocation of the sweepers?
Yes, Lordship. Because they have admitted that house was constructed by JHTC in their affidavit. After going to the affidavit, Lordship has found that to implement.
Yes, Miss Case number 42/2023, Info 59/2022. No objection. Yes? Yes. This is an application for implementing the secretary to Executive Committee, Garo Hills, Thomas Council, Tura, and also the Chief Executive Member of the as party respondents 5 and 6 in the instant proceedings done. Seen the grounds is made out in the petition. MS N. Raji Council also has no objection and accepts notice on behalf of the newly implemented respondents number 5 and 6. If paragraph in this case is allowed and disposed of. Next line, registry to make necessary corrections in the cause title in the main case. In the main case, in view of the order passed in this case number 42 so and so 2023, the secretary, the executive committee, the chief executive member GHEDC and the secretary, the executive committee GHEDC are implemented as party respondents number
5 and 6.
5 and 6. Petitioner to supply copies of the petition to the newly implemented respondents.
Lordship.
List after 3 weeks.
Lordship.
For affidavits and instructions from the newly implemented respondents. Yes, record.
12.
This matter is ready for hearing.
My lord, the respondent had filed the affidavit and we have filed.
You already filed a rejoinder also.
Received the rejoinder yesterday.
Yes.
Received the rejoinder on behalf of the petitioners. Sir.
Yes, party submit the pleadings are complete. This is for hearing.
Yes, yes, sir.
No urgency.
No motion.
No, this is a matter for hearing. On
13.
Boundary dispute matter, my lord, still pending in apex court, my lord.
Which one is this?
This is boundary dispute matter, my lord. Assam.
Challenging of lordship, an intervention application has also been filed, and lordship, this is coming up on the July 18th, lordship.
So then you will withdraw this matter now?
Lordship, no,
To
lordship.
pursue it before the
Not at the moment, lordship.
yes, MS room and the AG submit that the matter is still pending for Honorable Supreme Court. This is matter after 8 weeks. No point.
18th of July it's coming.
18th July.
18th of July.
It's coming
That
on
means that how many? This
May, June, July, it should be 12 weeks.
Because yes, June is holiday. At least after 12 weeks.
After 12 weeks, my lord.
14.
Highly obliged.
Yes, the respondent have not yet filed affidavit.
My lord, I'm appearing for the state respondent here, my lord. Lordship, may kindly give me some more time, my lord. 2 respondents.
It's not in file since 22.
My lord, December, my
MS,
lord. December, it's a matter of December.
Our only response allowed further 2 weeks time to file affidavit on behalf of state respondents.
15.
Lordship, in this matter, Lordship, the affidavit on behalf of the respondent number 2 is ready, Lordship. It has been signed and notarized, so I'll file it today. The other respondents, they are in the process of submitting the reply, Lordship.
Charmi submits the affidavit on behalf of respondent number.
Respondent 2, Secretary of
number 2.
Mission.
Will be filed in the course of the day. With regard to other respondents, submit the same also will be filed within 1 week.
Lordship.
Sorry, this is matter after 2 weeks, yes.
16.
For the orders. Yes.
May this is your lordship.
This, in fact, this petition is covered by Lordship judgment, which has been passed in. Arvind
You've seen
Lindo.
that, Mr. Walshree? What case is on?
This is, Lordship will recall, this is the case regarding those tainted teachers, Lordship. Lordship, if Lordship kindly come to paragraph 2 of this judgment passed by the Lordship.
Yes.
Lordship who were declared by the committee to be each bar and the rest 20 who were found not to possess the requisite mark out of the total number of proceedings. So, Lordship, in the present case, Lordship is almost similar, Lordship.
Lordship, you see the judgment?
No, my Lordship.
You give him a copy to judgment. With Mr. N.D. Shurai Leonard AG submits that the case of the petitioner is covered by the judgment dated 17/8/2022 rendered in WPC number 89/2021. Stop. By Mr. D. Wajari Leonard Constitutional Praise will have some time to examine the same.
Even it was carried into writ appeal also, Your Lordship. Writ appeal also has been dismissed. It's similar, Your Lordship.
Tired of these cases of teachers?
Teacher, Your Lordship, yes. Here we want that the decision of the 3-member committee to set aside, Your Lordship, which Lordship has.
Yes, you examine it.
Yes.
Just after 2 weeks.
Apply, Your Lordship.
Supplementary list. Item number 2.
Who was on legs yesterday?
If I understand correctly, my friend is finished.
Finished.
They have to reply.
Now replies by the final flourish.
I hope so.
Hopefully.
Hopefully. I will have to respond to about 6 primary issues that have been advanced by the respondent before my lord. Starting off with possibly the easier of the issues.
1 second.
Yes, ma'am.
Yes.
Starting off, my lord, with possibly the easiest of those issues raised by respondent. Reference, my lord, was made to clause 58.2 of the contract agreement.
Yes.
Now, if Lordship kindly looks at the petition, page 43, that is where 58.2 is located.
Today's 27th, correct? Yes.
Yes, my lord.
1 second, yes.
My lord. Page 43 of the petition, my lord. Yes. 58.2, my lord, was read by the respondent. With Lordship's permission, I'll read it just once more for the final time. 58.2, the court situated at the place where the headquarters of the corporation is situated, namely Shillong, will have the jurisdiction to entertain civil suits pertaining to the contract. So a lot of stress, my lord, was placed on the presence of the word civil suit, thereby attempting to persuade this honorable court that a section 34 application like the one which I have filed would not be covered under this clause, because this clause speaks only of civil suits. Now, this is an issue I had addressed in the last round of my submissions, but it is required to be addressed, to be reiterated again. Civil suits, my lord, this particular clause 58.2 cannot be read divorced from the context of the agreement, my lord. It has to be read along with the other provisions of the agreement, specifically, my lord, clause 71. Now, clause 71 is the arbitration clause. Now, once there is an arbitration clause, clause 71, that is, parties, whether they like it or not, are required to refer any dispute to arbitration. Once arbitration is activated, the natural consequences follow. Award is passed. Against that award, civil court can be approached by way of section 34 application, my lord. So the civil suit that is being contemplated in 58.2 can only be a section 34 or a section 9 application under Arbitration Act.
Yes.
There is no other possibility. In this connection, my lord, with your permission, I will refer to section 8 of the Arbitration Act. Section 8 of the Arbitration Act, and lordship is aware of this provision. Section 8, my lord, Section 8, power to refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submitting his first statement on the substance of the dispute, then, notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. So the reason why I'm highlighting this, my lord, is again just to reiterate the point that if there is a dispute, because of the presence of clause 71 arbitration clause, parties have to activate the arbitration process. However, if either of us, either me or the respondent, we choose to go to civil court, the other party will ensure that the civil court exercises power under section 8 and relegates the parties to arbitration. So in any reading of the matter, a civil proceeding in a civil court can only mean a proceeding arising out of arbitration. So civil suit has to be read in that context, my lord. It cannot be read divorced from the context of the agreement, my lord. That is one response. And secondly, my lord, if I'm permitted to place the reason why this particular word or the phrase civil suits exists in this particular agreement.
Yes.
Lordship, I noticed at the end of yesterday's hearing that this agreement, my lord, it's a fairly old agreement, an old format. This relates to the 1940 Act, my lord.
Right.
It relates to the 1940 Act, where Lordship is aware that after an award is passed by the tribunal, it has to be confirmed as a decree by civil court. So after there is an award, I have to file a suit in a civil court to get a decree.
So it is implied, you mean?
So this, the civil suit, that phrase flows out.
Implies that, it's a subsequent to a award.
To an arbitration proceeding. So civil suit, the presence of the word, of the phrase civil suit cannot be attempted to be used to exclude jurisdiction of Shillong courts in this particular matter, because it is an arbitration matter. Arbitration proceedings are also covered under 58.2. That is the first response to the respondents' submissions. Second, my lord, again, and hopefully again for the last time, I will have to take lordship's attention to the volume 4. Now, volume 4, my lord, a lot has been made out of the order at page 2028. So I will have to spend a few minutes on this order at page 2028.
Yes.
Now, contention has been advanced by the respondent that the fact that we had asked for change of venue, and the fact that we were told to file an application, and the fact that we never, for the next 14 years, never filed an application, shows that we had submitted ourselves to the venue of New Delhi, my lord. Lordship, I beg to differ. Irrespective of the submission that has been advanced by the respondent, I submit that my original submission in respect of these orders of the tribunal still holds good. My original submission yesterday, Lordship may recall, was that the fixation of the venue, for example, in this order, was only for the purposes of the next date. This order at page 2028, if Lordship kindly sees, the first paragraph, second line, for further arguments in this application, the case will be taken up on 23/1/2007 at 3:30 p.m. at the same venue. Now, the venue only for the next date was fixed. It is not a permanent venue that has been fixed for all time to come. Secondly, the second paragraph, where Mr. Sanjeev Rohatgi submits orally that the next hearing be fixed at Shillong, this suggestion can be considered only after a proper application is filed for change of the venue. The venue relates to the venue in the first paragraph. So it is not a permanent venue that was fixed at some point in the past. It is the venue that was fixed only for the next hearing. Mr. Sanjeev Rohatgi wanted a change of the venue of the next hearing. He was told file a petition. He did not file a petition. Matter ended there as far as the change of venue for the next sitting is concerned. So it is not like it cannot be.
So you mean to say that it was specifically only for the next date of hearing?
Only for the next date of hearing.
It doesn't imply that that
it was a permanent
change of venue. That
no.
Okay.
It does not imply that it was a permanent venue, and moreover, my lord, none of the orders it specifies the venue. It just says same venue, same venue, same venue. Finally, when the award is passed, there is an address given of New Delhi, but whether it is that address in which these proceedings, all of these proceedings were conducted, we cannot, the records don't reveal that. Point being, my lord, I go back to my original point that fixation of venue in this order and in every subsequent order, it is only for the purposes of the next date of hearing.
Yes.
So Mr. Sanjeev Rohatgi asked for a change only as far as the next date is concerned.
Yes.
He was told file a petition. Maybe he was not equipped to file a petition immediately. Matter ended there. Next date came. Hearing was conducted at the venue. Matter went on. So, with respect, nothing much can be made out of the fact that Mr. Sanjeev Rohatgi for the next 14 years did not file a petition, as he had been suggested, not even directed, suggested to do. That petition was for a very limited purpose, the purpose of changing the venue for the next hearing.
Okay.
And I would say most importantly, what comes out from this order is something very crucial. A submission has been advanced by the respondent that the fact that the proceedings took place at the same venue in New Delhi means that the venue was in a way agreed between the parties.
No, that's what he said, implied.
There's an implicit agreement. Lordship, first response is there is no concept of implicit agreement, implicit contract in law. there has to be express consent, express agreement.
This is your third submission.
This is on this issue only. On this issue, that what is the import, what is the importance of this order. Firstly, there is no concept of implicit agreement, impliedly agreed, impliedly submitted myself to the jurisdiction. No. Secondly, as I said, and I submit, maybe most importantly, this order itself reveals that there was no agreement between the parties. If Lordship recalls my submissions yesterday, I had referred to section 20, subsection 1. Section 20, subsection 1 gives the parties the right, the freedom to agree. Now, the fact that a venue is being spoken of by the tribunal, the fact that I am saying please change the venue means, what does it show? It shows an absence of agreement. If there was an agreement, implied or express, there would be no occasion, no chance for me, for my representative to ask for a change, if I had already agreed impliedly or expressly. So this order I submit, my last submission on this order is, it shows an absence. If anything, it shows an absence of agreement.
It reveals there's no agreement.
There is no agreement. Otherwise, there would be no occasion for me to ask for a change, if I had already agreed impliedly or expressly, my lord. Yes. This is my second submission, my lord, on this aspect of the orders in volume 4, in volume 4, my lord.
Right.
Thirdly, my lord, I will be now required to address the 4 judgments that have been referred to by the respondents. Various paragraphs have been referred to. Maybe I'm not required to address all those various paragraphs, but I will definitely be required to address the judgments as a whole, starting with Balco, my lord. If Lordship kindly looks at the judgment for, again, possibly for the last time. 2000. Now, Balco, my lord, various paras were referred to by the respondent. Now, all those paras referred to, even the paras that were not referred to, the entire judgment of Balco has to be read in a particular context, my lord. It cannot be forgotten, my lord, that the judgment of Balco, this particular judgment, was more on the aspect of foreign awards.
Exactly. That's why this court kept on saying yesterday that we have to the difference in foreign awards and
yes, my lord. And in fact, the
implementation of foreign awards and
yes, my lord. Yes, my lord. Foreign awards under part 2 of the Act. Yeah. Domestic awards, domestic proceedings are under part 1, which is our proceeding, my lord. In fact, Balco itself draws that distinction very clearly at para 124. Para 124. Para 124, my lord. Lordship has it.
Yes.
I'll read, my lord. Having accepted the principle of territoriality, it is evident that the intention of Parliament was to segregate Part 1 and Part 2. Yes. Therefore, any of the provisions contained in Part 1 cannot be made applicable to foreign awards as defined under section so and so, that is the New York Convention and the Geneva Awards. This would be a distortion of the scheme of the Act. It is therefore not possible to accept the submissions of Mr. Subramaniam that provisions contained in Part 2 are supplementary to the provisions contained in Part 1. Parliament has clearly segregated the 2 parts. So provisions have been segregated. There is a clear distinction and segregation. Consequence being that the principles of Part 2 cannot be made applicable to the provisions of Part 1. In that context, always remembering and keeping this in the back of our minds, the various paras have to be read. Para 123 was referred by the respondent. If I'm allowed to read para 123, thus Thus, it is clear that the regulation of conduct of arbitration and challenge to an award would have to be done by the courts of the country in which the arbitration is being conducted. Such a court is then the supervisory court possessed of the power to annul the award. This is in keeping with the scheme of the international instruments such as Geneva Convention and the New York Convention, as well as the UNCITRAL model law. It also recognizes, it goes on, my lord. The request was advanced by the respondent that in the second line, courts of the country should be substituted by courts of the country. The word country should be substituted by states. Now, such violence cannot be inflicted, my lord.
Yes.
To make such a substitution would be, as this judgment itself says, would be a distortion of the scheme of the act, my lord. Other paragraphs have been referred to. My response is on the same line, my lord. They all refer to foreign awards. You cannot import the principles governing foreign awards to domestic arbitrations.
Yes.
Having said that, just one last paragraph has to be addressed by me. That is para 95, my lord. And para 95 is required to be addressed because something that appears very important was submitted by the respondent with respect to para 95.
Party autonomy.
Territoriality, my lord.
Yes.
I'll just read a few lines from para 95, my lord. The learned counsel for the appellants have submitted that section 21E, section 20 and section 28 read with section 45 and section so and so make it clear that part 1 is not limited only to arbitrations which take place in India. These provisions indicate that the Arbitration Act 1996 is subject matter centric and not exclusively seat centric. Therefore, seat is not the center of gravity so far the Arbitration Act 1996 is concerned. We are of the considered opinion that the aforesaid provisions have to be interpreted by keeping the principle of territoriality at the forefront. We have earlier observed that section 2.2 does not make part 1 applicable. It goes on. Stress was laid by the respondents on the concept of territoriality and the fact that territoriality has to be the defining or the deciding factor. Now, conceding that territoriality is the defining factor, then where under which provision can we locate territoriality? Answer would be, my lord, in my humble submission, section 20 of the CPC. Now, under section 20 of the CPC, again, this is something Lordship has read a million times possibly, but if I'm allowed to read or just highlight one aspect from section 20. Keeping territoriality in mind, which court under section 20 would have the jurisdiction? If Lordship looks at section 20,
yes.
Section 20, other suits to be instituted where defendants reside or cause of action arises. Subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction. Clause A is there, Clause B is there, I focus on Clause C. The cause of action wholly or in part arises. So let us keep territoriality as the deciding factor. If territoriality is kept as the deciding factor, section 20 comes to my aid to the extent, because of the reason that their cause of action is what is.
But you signed the agreement in Shillong.
Absolutely. 2 judgments at page 16 and 17, I think, have been submitted to show that signing of agreement is enough cause of action, my lord. My last submission on Balco is, nowhere in Balco has it been stated that the court at the seat or the venue is to have exclusive jurisdiction. Nowhere.
Yes.
In so many words, nothing to that effect has been stated in Balco. That it is only the courts at the seat or the venue which will have exclusive jurisdiction. On the contrary, what has been stated in para 96 that it is two courts which will have jurisdiction. BGS, as respondents have pointed out, did attempt to, should I say, explain that para 96. I will address that part also. But point being that BALCO does not state, is not an authority that states that the courts at the seat or the venue are to have exclusive jurisdiction. Para 96 suggests something else entirely, my lord. That is as far as BALCO is concerned, my lord. Before going to BGS SOMA, just two more aspects which possibly came out of BALCO have to be addressed. One, my lord, a submission was advanced that this honorable court, exercising supervisory jurisdiction under 227,
confined to the yes,
may not have the jurisdiction because the genesis of the matter, according to respondent, came from the arises from the award. Award being passed in Delhi means that territorial jurisdiction may be absent of this honorable court. Lordship, I'm certain I don't need to spend too much time on this, but my response is an obvious kind of response. If the genesis is considered, if one step back is taken, and genesis, yes, my lord, there is no end to this backward linkages being drawn. If the award is the genesis, one more further step back would be agreement in Shillong. And there we come full circle. This honorable court would have the jurisdiction under 227. And the fact of the matter is, my lord, we are not challenging the award in this proceeding. We are not challenging the creation of the agreement, any provision of the agreement. We are challenging an order passed within the territory of this honorable court, my lord.
Sorry.
Yes.
Okay.
That was my fourth submission on Article 227. A fifth related submission is in respect of section 31, subsection 4 of the Arbitration Act. Passing reference was made to section 31(4) in the respondent submissions. I will have to spend 2 minutes on this aspect now.
No, take your time.
Yes, ma'am.
Yes.
If Lordship kindly looks at what exactly is 31(4). Section 31 speaks of the form and content of arbitral award. We are concerned with subsection 4. The arbitral award shall state its date and the place of arbitration determined in accordance with section 20. And the award shall be deemed to have been made at that place. So what comes out very clearly on a what comes out very clearly on a plain reading of subsection 4 is two things, my lord. There is a chronology, there is a flow under subsection 4. First, there has to be a determination by the tribunal.
Yes.
A determination of the place of arbitration by the tribunal, because it says place of arbitration as determined in accordance with section 20. Yesterday I had opened section 20, taken this honorable court through section 20. Under section 20, the determination that subsection 4 section 30 speaks of under section 20 is done under subsection 2, that is by the tribunal. The tribunal has to determine the place.
Yes.
Yesterday I had placed authority to clearly show there could not have been any determination, because determination requires a positive expression of opinion. In this case, there was no determination.
Yes.
Going back to subsection 434, first requirement is determination of place. Once place is determined, the award that is subsequently passed is deemed to have been passed at that place. So in reality, maybe in this case, for example, award may have been signed actually in Chandigarh, but because the place was determined, if it had been determined, it is deemed that it was passed
From the certain place.
At that determined place, my lord. So this is the chronology or the flow that is contemplated under subsection 4.
Yes.
Now, interestingly, the impugned order, the commercial court, while passing the impugned order, has addressed this 31.4, but has completely misread 31.4. If Lordship kindly looks at the petition, page 134. The petition, my CRP, my lord.
Yes, page
134, my lord.
134. Right. Para 37.
34, my lord. Para 34.
Page 134 or page?
134, my lord. Para
37.
I apologize. Sorry. Yes, my lord. Para 38, actually. 38.
No, the 37 because I think it was read by it flies in the face that is published and signed at New Delhi. So that means that the seat was determined. That's a finding of the
Lordship, I had read
37.
I had read 37 to show this honourable court that this is the same submission advanced by respondent before Delhi High Court.
Okay.
Subscribed to by the commercial court.
Okay.
But then I went on to show that determination requires something much more. You cannot the fact that sittings were held in proceedings were conducted in Delhi does not amount to determination, my lord. Now, in respect of 31.4, para 38 of the order, I'll read, my lord. It would be gainful to refer to section 31 of the Act 1996 to dispel the argument of the applicant that the tribunal did not determine the seat. Subsection 4 of section 31 of the Act 1996 envisages that the arbitral award shall state its date and place of arbitration as determined in accordance with section 20 of the Act 96, and the award shall be deemed to have been made at that place. Till here, commercial court is correct. In the instant case, there is no dispute that the award was made and published at Delhi. It is pertinent to take note that in subsection 4 of section 31 of the Act 96, there is specific mention of section 20 of the Act 96 for the purpose of determining the place of arbitration. In the instant case, the arbitral tribunal entered into the reference and the place of arbitration is showed in the impugned award as Delhi. In absence of juridical seat of arbitration in the agreement, inference has to be drawn from the date and the place of the arbitration mentioned in the award. There is a deem clause under subsection 4 of section 34 of the Act 96 for the purpose of determination of the place of arbitration. It is nobody's case that the tribunal held the proceeding at Delhi contrary to the agreement arrived at by the parties under subsection 1 of section 20 of the Act 96. What I have understood with my limited ability from this portion is that learned commercial court reversed the chronology. As the chronology which I had placed some time back was, first determine the place. Once place is determined, it is deemed that the award has been passed at that place. Commercial court picks up the word deemed and says that looking at the award, it was passed in Delhi, therefore it is deemed that it was determined. So chronology, the flow has been reversed. First, determination has to be there, then you can deem that it was passed at that place. He picks up the word deemed and says that since the award reflects a place.
So you mean he picks it out of context?
He picks it out of context. There is a flow in that subsection 4. He reverses the flow. He says that because the award on the face of it shows Delhi, therefore it is deemed, he goes back, therefore it is deemed that determination was done.
Yes.
No, that is not the way, with all due respect, that subsection 4 has to be read or applied.
So you only say that it cannot be deemed if there's no like concrete determination.
There has to be a determination. And what is determination? I have placed the authorities yesterday, my lord.
Right.
So deeming, the power to deem under 31.4 is after determination. You can deem that the award is passed at that determined place. He reverses it and says that because there is a place mentioned in the award, it is deemed that determination had taken place. He goes back, my lord. That cannot be allowed, my lord. That is my 5th point.
Last point.
Some indulgence, my lord. 2 more judgments are left.
Okay.
3 more judgments. My maths was weak. BGS Soma, my lord. I immediately go to BGS Soma.
2005
20,
volume 4.
2020, my lord.
2020 volume 4.
4. Now, BGS Soma, again, various paragraphs have been referred to. Now, before I'll address just 2 or 3 of those paragraphs which were referred to. But before that, before undertaking that exercise, again, I have to highlight that, like BALCO, BGS Soma is also not an authority which states that it is only and only and only the seat which determines the court. In some of the paragraphs referred to by the respondent, where BGS Soma suggests that the seat determines exclusive jurisdiction, it is in a very specific context. It is in a context.
It is a mix-up between BALCO, with the interpretation has been done to mix up part 1 and part 2, what has occurred in BGS Soma, in a way.
In a way, yes. In a way, yes. But even more than that, I would submit that BGS Soma at certain places, I have to concede, it is there in black and white. I have to concede that in certain places, certain paras, it does say that seat confers exclusive jurisdiction.
Yes.
But that principle is in a very specific context. That context is important. Para 49 was referred to in that connection, my lord. If Lordship looks at para 49,
yes.
Para 49, take the consequence of the opposite conclusion in the light of the fact of a given example as follows. New Delhi is specifically designated to be the seat of the arbitration in the arbitration clause between the parties. Part of the cause of action, however, arises in several places, including where the contract is partially to be performed, let us say in a remote part of Uttarakhand. If concurrent jurisdiction were to be the order of the day, as BALCO has suggested, despite the seat having been located and specifically chosen by the parties, party autonomy would suffer, which BALCO specifically states cannot be the case. Thus, if an application is made to a district court in a remote corner of Uttarakhand Hills, which then becomes the court for the purposes of Section 42 of the Arbitration Act 96, even where Section 34 applications then have to be made, the result would be contrary to the stated intention of the parties, as even though the parties have contemplated that a neutral place be chosen as the seat so that the courts of that place alone would have jurisdiction, yet any one of 5 other courts in which a part of the cause of action arises, including courts in remote corners of the country, would also be clothed with jurisdiction. This obviously cannot be the case. If therefore the conflicting portion of the judgment of BALCO in para 96 is kept aside for a moment, the very fact that parties have chosen a place to be the seat would necessarily carry with it the decision of both parties that the courts at the seat would exclusively have jurisdiction over the entire arbitral process. Seat confers exclusive jurisdiction so long as the choice of the seat has been made by the parties.
Okay.
In our case, undisputedly, no such choice has been made by the parties.
Yes.
Similar would be the case with the other paragraph referred to, that is para 53, my lord. Para 53.
Yes.
In Indus, Lordship has it, para 53, page 284, my lord.
Right.
In Indus Mobile Distribution so-and-so, after clearing the air on the meaning of Section 20 of the Arbitration Act 96, the court in para 19, which has already been set out herein above, made it clear that the moment a seat is designated by agreement, even more specific, between the parties, it is akin to an exclusive jurisdiction clause, which would then vest the courts at the seat with exclusive jurisdiction for purposes of regulating arbitral proceedings arising out of the agreement between the parties. So, designation of the seat in an agreement confers exclusive jurisdiction. There is no fight, there is no dispute with that proposition. But that proposition does not apply in our case.
Yes.
If that proposition does not apply, then where do we go? We have to go back to BALCO And para 49 suggests that. A more deeper reading of para 49 will show this Honorable Court that we have to go back to BALCO. There is no other option available. BALCO says there are two courts which have concurrent jurisdiction. If seat court is not available, then go to the court where cause of action arises.
Then after that, since you filed first, section 42 will apply.
Will apply, their petition also will have to come here. I would submit this is the distillation of the entire matter which Lordship has sought yesterday.
Yes. Right.
In our case, BGS would not really apply because the principle of BGS is in a very different context, designation of seat in the agreement between the parties. If there is an absence of that designation, we have to go back to BALCO. BALCO says two courts. If your seat court is not available, go to cause of action court, that is Shillong. And in summation, as far as BGS is concerned, I will draw Lordship's attention to one paragraph which, in my very humble submission, would seal the issue to a large extent. Para 59. Para 59, if I can read, my lord. Equally incorrect is the finding in Antrix Corporation Limited that Section 42 of the Arbitration Act 96 would be rendered ineffective and useless. Section 42 is meant to avoid conflicts in jurisdiction of courts by placing the supervisory jurisdiction over all tribunal or arbitral proceedings in connection with the arbitration in one court exclusively. This is why the section begins with a non-obstante clause and then goes on to state where, with respect to an arbitration agreement, any application under this part has been made in a court. It is obvious that the application made under this part to a court must be to a court which has jurisdiction to decide such application. The subsequent holdings of this court that where a seat is designated in an agreement, the courts of the seat alone have jurisdiction, would require that all applications under part 1 be made only in the court where the seat is located, and that court alone then has jurisdiction over the arbitral proceedings and all subsequent applications arising out of the arbitral agreement. So read, Section 42 is not rendered ineffective or useless. Also, and this is what I'm stressing on, also, where it is found on the facts of a particular case that either no seat is designated by agreement, our case, or the so-called seat is only a convenient venue, our case, then there may be several courts where a part of the cause of action arises that may have jurisdiction. I'll just pause, my lord, to reiterate. If no seat is designated by agreement,
yes,
according to BGS itself, then number one. Number two, where the seat may only be a venue, convenient or otherwise, they say convenient. Our case again. Then there may be several courts where a part of the cause of action arises that may have jurisdiction. BGS goes on to give an example in the same paragraph.
Yes.
Again, an application under Section 9 of the Arbitration Act 96 may be preferred before a court in which a part of the cause of action arises in a case where parties have not agreed on the seat of arbitration, and before such seat may have been determined on the facts of a particular case by the arbitral tribunal under Section 22 of the Arbitration Act 96. In both these situations, the earliest applications having been made to a court in which a part of the cause of action arises would then be the exclusive court under Section 42, which would then have control over the arbitral proceedings. For all these reasons, the law stated by the Bombay and Delhi High Courts in this regard is incorrect and overruled. Supreme Court gave an example of Section 9, that if there is a Section 9 petition to be filed, go to the court where the cause of action has arisen, in case your seat is not designated, has not yet been designated by the tribunal. Our case is that, my lord. Our seat had not been designated, either by agreement of parties or by the tribunal itself. Where do we go? We go to cause of action court, Shillong Court, my lord. They give an example of Section 9. If a particular court can take up a Section 9 application, it can very well take up a Section 34 application also. This aspect was addressed or was raised before the commercial court. Again, my lord, commercial court chose to give its own interpretation of things. This is at page 131 of the petition. Page 131. Lordship, somewhere in the middle there is an underlined portion, underlined by the court, my lord.
Before such seat.
Yes, and before such so and so. After the underlined portion, my lord. That's where the relevant portion is. The argument of the applicant placing reliance on para 59 of BGS SGS so and so would have assisted the application in an application under section 9 of the Act 1996 or any proceeding before commencement of arbitral proceedings. So interpretation of the Honorable the Learned Commercial Court is that this proposition under para 59 would apply only to a section 9 petition. Lordship, with all due respect, that cannot be, my lord. That cannot be. As I said, if a court can take up a section 9 application, it can very well take up any other section application, including a section 34 application also, my lord. That is as far as BGS is concerned. Just two more submissions, my lord, two more points. Seventh point, my lord. Judgment of Brahmani River Pellets was referred. That is 2020, volume 5. Now, Brahmani River Pellets was referred by the respondent. Two paragraphs were referred, that is at the end of the judgment. That is para 18 and para 19, my lord. If I can quickly just take lordship through these two paras again and put these paras in context, my lord. Small paragraphs. So, para 18, my lord.
Yes.
Para 18, where the contract specifies the jurisdiction of the court at a particular place, only such court will have the jurisdiction to deal with the matter, and parties intended to exclude all other courts. In the present case, the parties have agreed that the venue of arbitration shall be at Bhubaneswar. Considering the agreement of the parties, having Bhubaneswar as the venue of arbitration, the intention of the parties is to exclude all other courts. As held in Swastik, non-use of words like exclusive, jurisdiction only, exclusive alone is not decisive and does not make any material difference. Para 19, when the parties have agreed to have the venue of arbitration at Bhubaneswar, the Madras High Court erred in assuming the jurisdiction under section 11(6) of the Act. It goes on, my lord. What I would request Honorable Court to focus on is agreed again. Para 4 of this judgment may be referred to. And this clarifies the matter beyond any iota of doubt. Para 4, my lord. Para 4 says, clause 18 of the agreement between the parties contains an arbitration clause which reads as under. 18. Arbitration shall be under Indian Arbitration and Conciliation Law 1996, and the venue of arbitration shall be Bhubaneswar. Express agreement between the parties in the agreement itself. In that context, in that background, para 18 and 19 have been stated, where the Supreme Court has opined that choosing that venue means you have granted jurisdiction to that venue. So at the end of the day, we have to go back to the contract. Is there an express agreement as far as venue or seat between us? No. On the other hand, we have granted exclusive jurisdiction to Shillong courts to take up matters flowing out of the arbitration. We call them civil suits in this agreement, but they are matters connected to the arbitration process. They have to be matters connected to the arbitration process itself, my lord. That is Brahmani. And my last point, my last response is on the latest 2023 BBR judgment, which was 2023 1 SCC 693 BBR India Private Limited.
Yes.
Yesterday, my lord had asked me whether I'm aware of this judgment. In fact, coincidentally, night before last, I had come across this judgment. I had gone through this judgment. in my view, it was not required for either of the parties to place this judgment, because again in my view, there was nothing that this judgment added or subtracted from the real issue before this honorable court. This judgment, my lord, is more on the issue as to once a seat is designated, can it move around or does it remain static for all time to come? Answer was given in that context to that question that once designated, it cannot be shifted except by express consent of the parties.
Once like jurisdictional seat is fixed,
it is fixed forever, except if there is express and specific consent of the parties. On the other hand, in this judgment itself, what has been stated is seat is static, venue is mobile. Venue can move around from place to place. So
the whole difficulty comes because neither seat or venue is identified, only says place of arbitration.
Yes, my lord.
All this confusion is the reason, like all these cases that have come up, is only that, you know.
Yes, my lord. Yes, my lord. Yes, my lord. It requires the act itself, in my
yes,
very humble submission, requires a overhaul only in terms of certain language, my lord.
This act was made on the suggestions of your university.
Yes.
Incorporating, you know,
but I take no responsibility. I was not a student at that time.
That I believe that's what they say. Is it correct?
No, it was. I'm aware of that process that was undertaken, but I was I wash my hands of that process.
With seat and venue, simply left it at place.
Yes, no, I agree. So going back to this judgment, my lord, BBR. So as I said, it is an authority that says that seat is static, venue is mobile. Now, if venue is mobile, something that may be relevant is stated at para 30 of this agreement, of this judgment. Para 30 of this judgment.
Yes.
Maybe looked at, my lord. Para 30, my lord. I'll read. There are good reasons why we feel that subsequent hearings or proceedings at a different location other than the place fixed by the arbitrator as the seat of arbitration should not be regarded and treated as a change or relocation of jurisdictional seat. This would, in our opinion, lead to uncertainty and confusion, resulting in avoidable esoteric and hermetic litigation as to the jurisdictional seat.
What's hermetic litigation?
Hermetic, lordship, unnecessary use of fancy language, but hermetic would mean something that is isolated in a vacuum, doesn't really it doesn't really affect anyone else. It is just an academic exercise.
Like they say, putting two big words together doesn't make good English.
It doesn't. It doesn't.
You put some
it doesn't. And unfortunately, there is a tendency of our.
Anyway, let's not go there.
Let's not get into that. This would, in our opinion, lead to uncertainty and confusion, resulting in avoidable esoteric and hermetic litigation as to the jurisdictional seat of arbitration. The seat, once fixed by the arbitral tribunal under Section 22, should remain static and fixed, whereas the venue of arbitration can change and move from the seat to a new location. Venue is not constant and stationary and can move and change in terms of subsection 3 to section 20 of the Act. Change of venue does not result in change or relocation of the seat of arbitration. Now, why I'm highlighting this is because, if Lordship recalls, right at the end of yesterday's hearing, I had said that the dangerous aspect of this impugn order is the fact that it has taken venue to be the deciding factor. Yes. That because you have the venue is Delhi, therefore exclusive jurisdiction rests with Delhi.
Yes.
Now venue
it has cloaked venue with equal to seat. That's
equal to seat, my lord. Now venue, my lord, as this judgment reveals and as is logical, venue is mobile.
Yes.
So venue could be multiple venues. Now, would you have multiple exclusive jurisdiction courts, my lord, if venue is to be the deciding factor? It leads to absurdity and chaos, my lord. So other paragraphs 23, 34 have been referred to. In my very respectful submission, they don't really add anything to the issue at hand. Para 30, on the other hand, suggests that the approach of the commercial court is faulty for the reason that venue cannot be the deciding factor, my lord. having said that venue cannot be the deciding factor, I make my last submission by referring once again to the Shashwa principle, which I had alluded to yesterday.
Yes.
Now, Shashwa principle, if I'm allowed to just show one paragraph from BGS, that is para 60. No.
Volume 4. Yes.
Para 61. Para 61 rather. That is at page 289 of the volume. Para 61, just to understand once again what exactly is the Shashwa principle. Para 61, it will thus be seen that wherever there is an express designation of a venue,
yes,
and no designation of alternative place as the seat, combined with a supranational body of rules governing the arbitration and no other significant contrary indica, the inexorable conclusion is that the stated venue is actually the juridical seat of the arbitral proceeding. So Shashwa principle, to put it in very simple terms, simply says that when venue is designated, in our case not designated, but even for the purposes of argument, if it is assumed that it is designated, when venue is designated,
that suffice to be
and the seat is not designated, it is understood that venue is the seat itself if there is no other significant contrary indica. If there is nothing else to signify a contrary indication, a contrary intention.
But then Mr. Paul has argued contra that indicia is there, in the sense that this is consistently for 14 years. If you are sitting in a particular venue, cannot have all the ability of a seat.
Lordship, the fact that we participated at a particular venue would not mean that we have consented to the conversion of that venue into a seat, my lord. We have not. It cannot be implied.
So that is what. So the implication, you believe it cannot be taken lawfully. It cannot be taken to consideration that in the very fact 14 years at a particular place, when every order, that subsequent order which is passed along the line says venue, we cannot attach any importance to those what has been recorded to those orders.
Lordship, I have participated in at that particular venue, in the proceedings held at that particular venue, but I have never expressed an opinion or a view that I am comfortable with this venue, or I agree that this should be this should be deemed as the venue under section 20 subsection 2. Participation, in my very humble submission, would not equate or would not be equal to submission. Acquisitions of a particular state of affairs, my lord. I have participated.
So you maintain that notwithstanding the fact that for 14 years you've been participating in a particular venue, that no importance can be attached to that fact at all. It has to be disregarded if it doesn't come under the four corners of section 20, and whether a seat is not designated.
I'll just respond. By participating,
that's the only thing that is in the mind of the court. So I'm just voicing it.
Understood. I'm grateful that Lordship has expressed Lordship's mind on this issue. Participation at a particular venue would not amount to waiver of whatever defenses I may have in respect of
that's fair defense.
In respect of any challenge that I have to raise, that is available to me under law. So I have participated. There is no two ways about it. I have participated
for 14 years.
14. My friend says 19. Maybe
19 years.
19 years also. But my response is it could have been 14 years. It could have been 40 years, 14 days, my lord. That would be hardly material.
Will not cloak that venue with any.
I have not.
Elements of
my
a seat.
Participation has not cloaked that venue
with elements of a seat.
With the aura of a seat, my lord. So participation
aura is there, but elements of a seat.
The suggestion is there, but the qualification is missing.
Okay.
So I have participated. Now, as I said, even if I am to assume, let us assume that seat was designated, my participation has amounted to an implicit tacit agreement.
No, seat designated, there's no dispute anymore.
No, there also, my lord. If the seat is, so assuming that in our case, seat is designated by actions or by implication. See, sorry, my mistake. Venue. Sorry, my mistake. Slip of tongue. Venue has been designated by my actions, etc. Assuming that seat has not been designated, no dispute about that. If venue has been designated, seat has not been designated, the venue can be considered as seat if there is nothing significantly that shows some other intention.
No other indicators.
Yes, my submission.
That is what the only thing that indicator is there. Like, it's 19 years of proceedings which have been going on and
participation, my lord, cannot be used against me at multiple levels. My participation is first being used against me to show that you have submitted yourself to this venue. You have agreed that through your participation that this venue is the venue as contemplated under the Act. To that extent, even if I am to concede, even for the purposes of argument, again, I cannot be told that your participation is the significant contrary indica. My participation is a solo act, my lord. Significant contrary indica would have to refer to a dual act or an act conducted by both parties. In our case, the act conducted by both parties is agreeing to have Shillong as the jurisdictional court under the agreement. That is the significant contrary indica. That is what the approach Allahabad High Court had also taken in the judgment which I had placed yesterday in the exact same fact situation. According to Honorable Allahabad High Court.
So you say that you go to the root.
Yes.
That means you go back to the agreement, which is the genesis. That shows the expressed intention of the parties at that point of time.
Because in this entire...
So what happens later on cannot be held against you. And any act that's done before, like it's a consensual kind of act,
my lord,
like to decide when
my lord, I'm very happy that my lord has taken me on this in this particular direction. I humbly point out, my lord, that in this entire sequence of events over the last 20-25 years, possibly the only point where parties were ad idem of the same mind was at the time when the agreement was signed. At that time, what did both parties agree? That Shillong will have jurisdiction.
Only one thing is courts yet to understand is what will be like significant contrary indicia. That's one. What will those words mean?
Yes.
Significant, contrary,
indica.
Contrary. Contrary means contrary to the express intentions that you made in the agreement also.
No.
Okay.
The significant contrary indica has to be read with the previous requirement of the Shashwa rule, of the Shashwa principle. Shashwa principle requires, number one, designation of venue. So, assuming in our case some through my actions,
that will serve as a seat. That ends there.
So, so first requirement is designation of venue. Second requirement is non-designation of seat. Once these two conditions are there, if there is no significant contrary indica, that means any indication that the parties did not want to invest or clothe the venue with the status of a seat, if there is any indication, contrary indication, if there is nothing, no contrary indication, then venue is to be treated as seat. In our case, the agreement contains the contrary indication. By saying that Shillong will have exclusive jurisdiction, parties very clearly gave a contrary indication that venue, very well, you can have a venue, etc. But we do not want any other place to have any other special status. But in this case, the status of a seat, we want Shillong court to be the relevant court, the principal court. So, to answer Lordship's question, in what way does the expression, the phrase significant contrary indica have to be read or understood? It has to be read juxtaposed against the requirements of the Shashwa principle, which is designation of venue, non-designation of seat, in which case venue becomes the seat unless there is a significant indication that parties wanted something else. In our case, parties definitely wanted something else, Shillong courts to have jurisdiction.
Okay.
So that, I believe, is the end of my submissions. Unless my friend makes
I don't
further
think you
submissions.
have no more submissions, correct, Mr.
I would
Paul?
hope not, my lord.
1 minute.
I hope your 1 minute doesn't.
1 minute. Just two things to aid, my lords, two queries which have fallen from this court. I'll very quickly, my lords, just take your lordships to 1 page of this, 2 pages of volume 4. Because that is only for the purposes of, my lords, the query that has fallen from your lordships regarding significant contrary
Indicia. It's indica, indicia.
Indicia. That's what I think. My friend prefers to call it indica. Well, I'll quickly take your lordships to page 1801. Where again the principle of acquiescence and then submitting to Delhi Millets comes in. A very interesting document. I missed it yesterday, so I thought I should have placed it for your lordships. 1801 Millets. The document starts from page 1791.
1801.
Millets. Relevant page is 1801. It starts from 1791. This is the section 16 application filed by them before the tribunal at the first instance. This is document P6. My lords will kindly see the
P7 or
verification.
P6?
Yeah, P6, my lords. 1791 it starts, and my lords, it ends at 1801. Your lordships will kindly see the verification.
Yes.
I so and so, 41 years of NEPCO, Shillong. Now, very interestingly, my lords, I so and so, manager law, NEPCO, Shillong, do hereby verify and state the statements made in paragraph so and so to the as derived from the records, which I believe to be true, and the rest of my humble submission for the arbitral tribunal. And I sign this verification on the 12th day of May 2006 at New Delhi.
Okay.
So the section 16 application is verified in New Delhi, even though, my lords, the address of the respondent is shown as Shillong. That's the first indicator, my lords, that they have, my lords, I won't say conceded, my lords. I would rather say that they have, in a very tacit manner, accepted Delhi as the thing. Now, the other page in this document, my lords, would be page 1792, if your lordships kindly have paragraph 5. This is your lordships will kindly keep in mind, this is a section 16 application.
Page?
Well, it's 1792.
1792, okay.
Paragraph 5.
Okay.
This is the challenge to the arbitral proceedings, fellows. That in furthermore, clause 71.1 of the arbitration agreement between the parties, which prescribes for arbitration of disputes and is extracted later herein, also requires that an arbitration shall not be commenced without settling the specific terms of reference. It is stated that the claimant has made no effort to settle the terms of reference with the respondent. It is submitted that the entire proceedings are therefore without jurisdiction. Your lordship will kindly keep one thing in mind. At the time of settling the terms of reference, my lords, it is understood, or the law on this issue is that the determination of the seat, as my learned friend was arguing under section 22, would already have to be made. Now, if that is the position, my lords, there is no challenge by them with regard to the determination of seat. The only challenge by them is with regard to the terms of reference. And that too, my lords, on a verification of an application which is verified at New Delhi. Okay. This is, my lords, I cannot open up facts at this stage, my lords. I just thought I should point this out. Very quickly, I'll just take my lords on 2 issues that my learned friend has placed. Your lordships have seen, my lords, section 31.4.
Yes. Deemed.
And what had been argued by my learned friend, my lords, a lot of credit to him for the manner in which it was placed. If I may just read it again, my lords. The arbitral tribunal shall state its date and place of arbitration as determined in accordance with section 20, and the award shall be deemed to have been made at that place. Now, my lords, this would have to be, to my humble understanding of this, when the award is finally signed, there are 2 factors that are mentioned. One is the date and one is the place. Now, what is that place, they say? Place is as determined by under section 22.
Right.
I will take your lordships very quickly to that award.
Award is in your petition.
It very specifically mentions, my lords, New Delhi.
No, my lord, it's in volume...
volume 4. Volume 4. Sir. No, it's volume 1. My apologies. My apologies. Yeah.
What's the weight of each volume? It's getting some exercise. Yes.
Page 59, minutes.
59.
Your flag.
Right.
Well, it's paragraph 125 that this award is made and published at so-and-so as SFS DDA Flats, East Mukherjee Nagar, Delhi, on this the so-and-so, and has been printed on stamp paper of rupees so-and-so. Coupled with the fact, Malaj, that the stamp paper procured for the purposes of this award is in New Delhi. So, Malaj, the requirement of section 31(4), if it has to be understood from the plain reading of the award, the determination of the venue, as my learned friend has been consistently arguing before your lordships, is settled by virtue of the fact that the address which is mentioned in the award mentions, Malaj, New Delhi. Unless the
award has been made in New Delhi. Correct.
Award is made in New Delhi. Your lordship will kindly see the language of 31(4) again, Malaj.
Yes, no quarrel with that.
Malaj, if I may read section 31(4) again. The arbitral award shall state the date, and the place of arbitration. There is no comma in between, Malaj. Lordships will see the place of arbitration as determined in accordance with section 20 of the, as determined with section 20. And then we come, Malaj, and. So there is a break in the sentence. So any place which is mentioned in the award, in my humble submission, will essentially be the determination of the seat by the arbitral tribunal, unless something can be produced by the party contesting this finding, saying that no, there is some tangible material before the court which would suggest otherwise.
Determined in accordance with section 20. There has been no determination in accordance.
My lords, that is the submission of the petitioner.
Yes. There's been no determination.
A plain reading of the award would suggest otherwise. The test of determination that what my learned friend had placed before your lordships, and I'll take, just to give you the compilation, filed by my learned friend yesterday. My friend had referred to the law lexicon, Millets.
Determination.
Yes, and your lordship may kindly have page 18, what was read by my learned friend.
Yes. The express determination.
Expression signifies an effective expression of opinion, which is what the law requires under section 34. Effective expression of opinion which ends a controversy or a dispute by some authority. So the quietus to this entire controversy of whether there is a venue, whether there is a seat, the law requires, it's a requirement of the law. And your lordships would recollect that this requirement was not available under the earlier law. Where Balco and BJ Soma have both placed reliance on this, my lords, that this now the award not only requires you to mention the date, it also requires you to mention the place.
Yes.
Why the place, my lords? And your lordships will again see there are no commas segregating this portion after, my lords, the arbiter shall state the date and the place of arbitration. There is no comma after that. So it has to be read, my lords, and the place of arbitration as determined in accordance with section 20. So any place which is written in the award is the determination under section 20.
That still, anyway.
That's my humble submission to your lordships, but your lordships will.
Yes. It is a bit roundabout, but that's it.
There is only one thing that my learned friend had said, my lords, regarding 58.2 and 71. Where they are trying to say, Malaj, that civil suits, when we are talking about civil suits, with essentially be anything connected with an arbitration. Now that cannot be primarily because of two reasons. Lordships will kindly
keep in mind, the thing is that when this agreement was drawn up, it was 1940
under the old act.
Was in mind.
Old act.
Under the old act.
My lords.
So this new Act 96 hadn't come into play.
Hadn't come into play.
Right.
My lords.
And so that's why when it says civil suit, but at that time an award has to be a decree by a court.
My correct. Lords, made decree by a court in respect of an arbitration. I was just coming to that.
Right.
That is the culmination of the award of the arbitration.
Right.
That is cannot be confused with a civil suit. Your lordship, there are two aspects to that. Parties could be referred to arbitration under section 8, or they could have gone. Ultimately, the award would have been passed, and then we have to carry it to a civil court.
The very presence of an arbitration clause Which relegates party to arbitration.
Arbitration.
Like presupposes that there's no question of, its civil suit would arise only under
Well,
34 and
arbitration
application subsequently,
no,
not before that.
Arbitration could happen only with regard to the parameters under which, my lords, the arbitration clause is there. 71 is therefore very specific. It is not a normal arbitration clause. I will take your lordships to 71 again. Your lordships may kindly quickly glance through 71. My friend has annexed it, my lords, at page 44 of the revision application.
Page
44. Your lordships, the arbitration clause, my lords, as is available in present day contracts, is essentially a one paragraph contract, that any dispute or difference arising out of the contract, you will go in for arbitration. My lords will kindly see how this arbitration clause is framed. The agreement authority for this contract is the Northeastern Power Corporation and is represented by the Chief Engineer. As far as the contract is concerned, the Chief Engineer is represented at site of work by so-and-so, 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 my lords. These officers at site are delegated with certain powers regarding execution, measurement and power of works. The commitments made by these officers at site of the engineers are based on interpretation of agreement made by them. It may sometimes happen that the corporation chief engineer does not agree with the views of its subordinate officers and may have an entirely different view as far as the interpretation of a clause in this agreement is concerned. In such cases, the corporation chief engineer shall have the full right to revoke the decision made by each of his subordinate officers and on direct adjustments and payments based on the final decisions of the corporation chief engineer. Such decisions of the corporation chief engineer shall be communicated to the contractor under the title decisions revoked by the chief engineer corporation and shall be binding on the contractor. Subject to the above stipulation, if the contractor considers any record or ruling of the corporation chief engineer of its subordinates or authorized in respect of the provisions of this agreement or considers any work demanded of him by the chief engineer to be outside the requirements of the contract, he shall immediately upon record of ruling being made by such work being demanded, ask in writing for written instructions or decisions. He may file a written protest with the chief engineer stating clearly in detail the basis of his objection, except for such protests and objections are made on record and the manner hereinafter specified, and with the time limit started, the records, rulings, instructions and decisions of the corporation or chief engineer shall be final and conclusive. Instructions or decisions of the chief engineer contained in its letters transmitting drawings to the contractor shall be considered as objections, and instructions, decisions subject to protests or objections as hereinafter provided. If the contractor is dissatisfied with the final decision of the chief engineer or the contract corporation or the protest or objection made by the contractor in accordance with the procedure prescribed under so-and-so, the contractor may within 15 days after receiving such decision give notice in writing to the chief engineer requiring the matter to be submitted to arbitration, furnishing full detailed particulars of the dispute or difference, specifying clearly the points of issue. If the contractor fails to give such notice to the chief engineer within a period of 15 days as stipulated, the decision of the chief engineer shall be final. Thereafter such issue shall not be subject matter of arbitration. Okay. And then, my lords, it goes on where arbitration can be initiated at the instance of the corporation, where, my lords, I can initiate arbitration. So it is not essentially, my lords, as it is worded in today's language under the 96 Act, where we say that any difference,
any dispute, yes, sir,
or dispute arising out of anything under the contract will go in for arbitration. So the scope of civil suit, my lords, as has been pointed out at 58.2,
has not been cut off. Yeah, I mean, it still survives.
There are areas, my lords, where civil suits would be maintained. And why I say this, your lordships will kindly see, if the understanding, if this is to be interpreted in a harmonious manner, my lords, your lordships will kindly appreciate. 58.2 would not provide for civil suits and 71.1 will not provide for arbitration. It would be the other way around. In contemplation of arbitration, which is provided in 58.2, at 71, probably you could have a clause which says civil suits. So, and we definitely cannot confuse the fact, my lords, that an award which has to made the rule of the court under the 1940 Act would come within the definition of civil suit. So, my humble submission is, my lords, there is no contrary indication or indicia for the purposes of not applying the Shashua principle, coupled with the fact, my lords, 14 years, 19 years, as I don't know who stands correct, and the fact, my lords, that the award itself specifically mentions New Delhi as the place of arbitration, which in my humble submission would be the determination as required under section 22.
Yes.
And in section 16 application, my lords, they have only gone on to the record regarding the terms of reference. They do not talk about the determination. what my learned friend was submitting is that simply because they have participated in a proceeding before a certain tribunal for 14 years or 19 years would not bind them insofar as at a subsequent stage challenging.
The thing is, yes, that in that implication or implied that's.
It would be similar to me, my lords, contesting a suit before a certain court for 19 years. And thereafter, one fine day, saying that no, this court does not have the jurisdiction, I will go back to some court in some other part.
No, you can't draw the analogy. It's totally different thing. Yes. Right.
Obliged. I'm grateful to your lordships.
But I think you'll have to give bullet points.
Bullet points.
I'll just give bullet points. Yes.
Lordships would grant us a couple of days.
Yes, yes. I mean, yeah, we'll fix this after 1 week for bullet points by the parties. Interesting point, because there's a implied thing troubles the court with regard to value, because very good arguments have been made, which are,
Hopefully, my lords, once the judgment is delivered by your lordships, it would be flagged in some other court by some other person when they would be faced with similar circumstances.
I hope it's get flagged and not flogged. Like
flagged for somebody, flogged for somebody.
Someone was remarking, this other judge, he said like this certain court, certain, you won't name it, he's been responsible for landmark decisions, but for landslide decisions. So that creates more problems.
Item number 3. Item number 3, supplementary list.
How long will it take, Mr. Majao? Because we have a program at
senior advocates are there also.
The order dated 3/11/2022. This Honorable Court has directed the petitioner to produce the certificate.
Order?
3/11/2022.
Yes. Yes.
This Honorable Court has directed me, Your Honor.
Yes, where's the qualification?
To ascertain the authenticity of the certificates, my educational qualification, Your Honor. Whether the same is equivalent to matriculation or not, Your Honor.
Yes.
So I've got this information, Your Honor.
They have supplied us a copy, my lord. Let them file.
Where's the government? Mr. Kharmi is here. Was Abraham?
Abraham is on leave. I am not in this case now.
Yes, what's the...
Yes. If your lordship, come to the second page, lordship.
Go on the second page.
Yes, your lordship. There's a name of institution, your lordship. There's Assam Rashtra name of examination recognized. Prabhat, that is the qualification I have, and the same is equivalent to HSLC, your lordship.
So does that meet NET stipulation?
Yes. Yes,
your lordship. Does it meet
the
qualification?
Yes, your lordship.
Have you given a copy to him?
I've given him, your lordship.
My lord, we would like to file a response to this.
Whether required or not, your lordship.
In fact, it will be appropriate for the petitioner to file this.
Whether it's required,
affidavit, yes.
Yes, my lord.
If you want to go to take cognizance of this, you have to file with affidavit. Yes, Mr. Armojao submits that
pursuant to order dated.
Pursuant to the order dated 3/11/2022, he has obtained a communication, a press note indicating that the qualification possessed by the petitioner is sufficient for holding the post of Hindi teacher.
Yes.
He prays and is allowed to bring the same record by an affidavit. Yes, just a matter of 2 weeks for hearing. Respondent permitted also to file any objections within the set time.
Item 22, main list.
This matter, Mr. H. Abraham is appearing for the private respondents, lordship. Let it come after 1 week.
Yes.
No objection, your lordship.
Mention made Mr. H. Abraham under GA.
No, he is for private respondents.
Oh, for private respondents, not present court today for adjournments. Prayers allowed this after
1 week.
1 week. You've disappeared for many days?
Yes, your lordship.
You're on a long holiday?
Your lordship.
Very good. Yes. Yes.
Dịch xong thì là